evening. Good evening. Thank you. Thank you. Thank you for being here, for taking time to come out to the Dorothy L. Thompson Civil Rights Lecture Series. We have a tremendous program for you tonight. Before I make formal introductions, let me just do a few housekeeping chores. I would like to ask, if you have cell phones on, if you would turn them off or either put them on silent mode. I would appreciate it. Also, immediately following, there will be a reception with refreshments immediately following outside of this particular hall. So please keep that in mind. Let me, for a moment, tell you something about the person for whom this lecture series is named. In recognition of Dorothy L. Thompson, it is fitting that the contributions to the field of human rights and throughout the campuses of universities in Kansas and certainly here at Kansas State University, this particular lecture is named in honor of someone who recognized and appreciated human dignity, who recognizes human rights and civil rights, and was a champion of diversity. Dorothy was associated with Kansas State University from 1971 until her death in 1992. From 1972 to 1985, she served as the university's affirmative action director. She took a leave of absence from her affirmative action post from 1976 to 1974 to attend and received her law degree from Washburn University Law School. Dorothy was a model for women and attorneys in Kansas. She was highly regarded by persons of all political learnings for her democracy, her diplomacy, and her effectiveness. Dorothy had an abiding respect for all people and a profound commitment to fairness and equality. A civil rights lecture series is a particular fitting memory for her. And this lecture series is sponsored and supported through the office of the provost, Dr. Wayne Nellis. I want to also, before we begin, to ask the members of the Dorothy L. Thompson Civil Rights Lecture Series if you would stand and be recognized by this audience. If I would take time to highlight the accomplishments of these individuals who sit before you, we would not have the privilege to hear what they have to say. But I will, in honor of them, talk about them so you will get a sense, a brief sense, of who these respected and honored guests are. First, let me introduce Honorable Nancy Kaplander, Judge of the Court of Appeals from 2004 until present. If you would stand. Judge Kaplander grew up in a big family in the small community of Tipton near the beautiful Blue Hills of north central Kansas. Judge Kaplan received a BBA from Washburn University in 1982 and her JD from Washburn Law School in 1985, where she served as the notes editor of the Washburn Law Journal. She worked in the civil division in that office in Kansas City and later in Topeka until 1999, where she became the appellant coordinator for the United States Attorney's Office, a position she held until she was appointed by Governor Kathleen Sebelius to the Kansas Court of Appeals in October of 2004. Throughout her legal career, Judge Kaplinger has served on the board of editors of the Kansas Bar Journal and was the first woman to chair that organization. She has also served on the Kansas CLE Commission, the 10th Circuit Advisory Committee, and the Board of Governors of the Washburn Law School. Judge Kaplinger and her husband, Topeka attorney Mark Kaplinger, have a blended family of 4 daughters, Kathleen, Jessica, Sarah, and Kate. Their family lives in southwest Shawnee County, and the girls attend Washburn Rural Schools. Please welcome our honored guests. Honorable Henry W. Green, Jr., Judge of the Court of Appeals since 1993. Judge Green, Jr. was born in Leavenworth. He received his undergraduate degree from Kansas State University with a dual major in history and political science in 1972. He is a 1975 graduate of the University of Kansas Law School, where he served as vice president of the third year class, and a researcher assistant. From 1979 until his appointment to the court, he served as a member of the United States panel of bankruptcy trustees for the District of Kansas. Active in local, state, and American bar associations, Judge Green is a former president of the Leavenworth County Bar Association and formerly served on the membership committee of the Kansas Bar Association. He is a lecturer and co-author of successful creators strategies in bankruptcy in Kansas. He also serves as a pro bono counsel for the Buffalo Soldiers Monument Committee, which raised more than $1 million for the erection of the Buffalo Soldiers Monument. Judge Green is currently a member of the Kansas Board of the Discipline of Attorneys, a position he has held since 1992. Judge Green and his wife, Shirley, have 2 children, Monica and Malcolm. Please welcome our honored guests. Honorable Richard D. Green, Judge of the Court of Appeals since 2003. Judge Green was born in Hermann, Missouri. He received a BS in Business Administration from the University of Missouri in Columbia in 1972 and his JD from Southern Methodist University in Dallas in 1975. Upon graduation, he practiced law with the firm Morris, Lang, Evans, Brock, and Kennedy for 28 years. Governor Kathleen Sebelius appointed him to the Court of Appeals in June of 2003. Judge Green attended appellate judge school in the summer of 2004 in New York University. He was appointed by Chief Justice K. McFarland to sit with the Kansas Supreme Court on numerous cases during the 2007-2008 term, and in that capacity, he authored 2 published opinions for that court. Judge Green currently serves as chair of the Kansas Bureau Association Annual Survey of Law Committee and as a member of the KBA's Bench Bar Committee. Judge Green was named the 2005 Benson Distinguished Speaker by the 13th Judicial District Bar Association, and he was the Outstanding Service Award from the Kansas Bar Association in 2008 for the distinguished service to the profession. He remains active in his church, where he teaches a Sunday school adult class. Judge Green and his wife, Mary Sue, has a blended family of 4 daughters, Kristen, Julie, Katie, and Jenny, and 3 granddaughters, Ashton, Savannah, and Chandler. Please welcome our distinguished guests. Stephen Cisneros, Executive Director of the Kansas Hispanic and Latino American Affairs Commission. Governor Kathleen Sebelius appointed Wichita native in 2007 as Executive Director of the Kansas Hispanic and Latino American Affairs Commission. Serving as a liaison for the Kansas Hispanic and Latino community and the Office of the Governor, the Commission addresses public concerns primarily in the areas of education, health, and business. In his present post, he is accountable to the Governor for a number of Commission critical programs and initiatives. As the principal point of contact in the state of Kansas for promoting the advancement of Hispanics in all aspects of Kansas life, he oversees a statewide operation serving the rapidly growing Hispanic population. Early in 2001 to 2003, he was the chief advocate and federal legislative consultant for the transportation and infrastructure clients of Jefferson County Jefferson government relations, and he additionally secured federal funding for medical and educational clients. He also served as a legislative consultant for both public and private sector clients in matters of the United States Congress and federal agencies. In 1999, President Bill Clinton appointed Stephen as a Special Assistant to Secretary of Transportation, Rodney Slater, where he served as Communications Liaison and Special Projects Coordinator for the Secretary of Transportation and the National Highway Traffic Safety Administration. He received a BA degree from Wichita State University with a major in political science. Please welcome our special guest. Attorney Danielle Dempsey Swopes. Is Executive Director of the Kansas African American Affairs Commission. Danielle began her work as the Assistant Director of Affirmative Action at Kansas State University in the fall of 1992. Danielle left Kansas State University in 1996 to become Associate Director of the Equal Opportunity at the University of Kansas. In August of 2003, she was appointed by the Governor to serve as the Executive Director of the Kansas African American Affairs Commission. In the spring of 2004, Danielle spearheaded an effort to pass legislation to move the Kansas African American Affairs Commission from the Kansas Department of Labor to the Office of the Governor. During the 2005-2006 legislative sessions, Danielle worked with legislatures to draft and pass Kansas legislation prohibiting the act of racial profiling by Kansas law enforcement agencies. Currently, Ms. Danielle Swope serves as administrator to the Governor's Task Force on Racial Profiling. Ms. Danielle Swope continues to serve on many state advisory boards and commissions and provides training in many areas related to leadership, diversity, and legislative matters. Please welcome our special guest. And last but certainly not least, Attorney Kyle G. Smith, our moderator, is the Topeka Department Labor legal advisor to the Topeka Public Police Department. Applause. Kyle received his law degree in 1981 from the University of Kansas. For the next 6 years, he served as a prosecutor in the Lyon County Attorney's Office in Poyer, Kansas. In 1987, he was appointed Assistant Attorney General and General Counsel to the Kansas Bureau of Investigation. In 1990, he was transferred as Assistant Attorney General to a newly formed narcotics strike force unit within the Kansas Bureau of Investigation, and also commissioned as a law enforcement officer. In 2001, Mr. Smith was promoted to Director of Public and Governmental Affairs, and in 2005, he was again promoted to Deputy Director of the Kansas Bureau of Investigation. Mr. Smith's duties include legislative liaison, media relations, training, firearms instructor, corruption investigation, and grant coordinator. Mr. Smith also assisted and advised other law enforcement agencies and prosecutors in complex cases. In 2007, Cal Smith was appointed Executive Director of the Congressional-funded National Alliance of Modern State Drugs Laws in Alexandria, Virginia. In 2008, he returned to Topeka and now serves as legal advisor to the Topeka Police Department. In addition to providing instruction with the Kansas Bureau of Investigation, Mr. Smith has lectured prosecution and law enforcement agencies, organizations across the United States and internationally on controlled substance issues, legislation, and other criminal topics. Please welcome our moderator and special guests. At this point, he will give the charges for the evening.
Thank you. Thank you very much. Thank you all. And thank you. The charge is to be open and to participate. This is a tough topic. It is a real topic. It's a serious topic. But it's like a marriage. It doesn't get better if you don't open up and talk about it. I'm divorced, so I know what I'm talking about. So we're going to have the panel talk briefly, say a few opening remarks. Then I'm going to throw a few questions, nice softballs. Right. And then we'll let you participate. And if you have a question that's burning and you have to get back for something, feel free to raise your hand earlier. I know what you're all thinking. Why is the middle-aged white guy the moderator? Obviously, it's not a lot of personal experience, but one of the things that was not in my way too long bio is I was also legal counsel to the Kansas Commission on Peace Officer Standards and Training. And for 20 years, I was in charge of disciplining law enforcement officers as their counsel for the commission. And I also investigated and prosecuted law enforcement officers for malfeasance and misconduct at the KBI. So I think that, and I was free for the evening, is why I got the job as moderator. So, without further ado, I think I will turn to our judges. They cannot answer questions about pending litigation, the way judges are. On the other hand, this is my one chance in my life to cut off a panel of the Court of Appeals judges instead of them doing it to me. So we will cut them short if they ramble on too long, just because I want to. Do you all have a particular order you wish to go in, or Judge Green, are you going to do an overview of the statute? Or?
Yes, if I may.
Please.
Let me first of all express my thanks and the thanks of my colleagues for the invitation to participate in this panel. We consider it a privilege to come to Kansas State, not only for this lecture, but in connection with all of your Constitution Day activities. We happen to think Kansas State does an extremely good job of meeting the congressional mandate in celebrating Constitution Day, and we're very proud to be part of it. I want to start by saying that racial profiling is indeed appropriate for our focus here on Constitution Day. We're going to talk probably quite a bit tonight about statutory framework here in Kansas, how it works or how perhaps it doesn't work as well as it could. But we don't want to miss the fact that the roots of this issue are in the Constitution and the principle of due process and equal protection. And just because it happens to be around Constitution Day, let me quote for you from Amendment 14 to the United States Constitution, that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. It's particularly that concept of equal protection that we turn to when we examine the whole question of racial profiling. No matter one's color or ethnicity, persons are not to be deprived of liberties on this basis, and for that matter, they are not to be singled out for investigation on that basis. Now, in addition to that sort of constitutional roots, I want to say that we often discuss this question in connection with the Fourth Amendment as well. And I'm sure You're quite familiar with the Fourth Amendment. Actually, our court does a lot of work in this area. And Amendment 4, just again, so that we all have that firmly in mind, from the United States Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So again, we see the Fourth Amendment also providing a context for a lot of our discussion and focus this evening, because indeed, the people are not to be searched or seized solely on the basis of color or ethnicity. In fact, that process is not to be tolerated. Now, let me just take a few minutes to overview the Kansas statutory framework as it currently exists. I'll make a few comments about a bill that was pending in our legislative session this year, which did not pass, which would have strengthened some of what I might point out as potential weaknesses of this statutory scheme. But I think you should all know right up front that in Kansas, racial profiling is prohibited by statute, no question about it. The legislature passed that in 2005. It is codified, for those of you who particularly pre-law students, in KSA 22-4606 through 4611. I'd like to overview a few of its features before I turn over the mic. It is unlawful to engage in racial profiling. 22-4608 specifically says it shall be unlawful for any law enforcement officer or any law enforcement agency to engage in racial profiling. Now, we have a definitional section right up front in 4606, which will define some of those terms that you just heard me quote from the operative statute 4608. And specifically, I want you to notice some aspects of these definitions that I think we'll need to discuss probably some more as we go along tonight. First of all, the definition of racial profiling means the practice of a law enforcement officer or agency relying as the sole factor on race, ethnicity, national origin, gender, or religious dress in selecting which individuals to subject to routine investigatory activities or in deciding upon the scope and substance of law enforcement activity following the initial routine investigatory activity. Racial profiling does not include reliance on such criteria in combination with other identifying factors when the law enforcement officer or agency is seeking to apprehend a specific suspect whose race, ethnicity, national origin, gender, or religious dress is part of the description of the suspect. Okay, you'll notice the phrase "as the sole factor" within that definition. And we might discuss whether that serves to somewhat weaken our statutory scheme, because indeed, if there were other factors involved, you see, we're not within the definition of racial profiling. A law enforcement officer, to give you an example, needs only to articulate a second factor, and I would argue the way the statute is put together that he could ascertain that second factor later in order to justify a stop or a seizure. A second potential arguable weakness in the statute is 4606E, which defines routine investigatory activities. The statutory definition is that it includes but is not limited to the following activities conducted by law enforcement officers and agencies in conjunction with traffic stops. Number one, frisks and other types of body searches. And number two, consensual or non-consensual searches of persons or possessions, including vehicles, dormitory rooms, school lockers, homes, and apartments. Now, what's not within that definition that what could be in it to make it stronger? It does not specifically include seizures, which you noticed when I read Amendment 4 to the U.S. Constitution, goes hand in hand usually with searches. It does not include, routine investigatory activity does not include questioning. Does not include questioning. It also does not include an investigatory stop. So that's just something to think about as we talk about where we are in Kansas with the whole question. Based upon the definitions, one could argue that a number of activities escapes coverage by this statute. Pulling a car over is not part of racial profiling. Asking questions of a driver is not part. Observing the interior of the vehicle upon its being stopped. Checking for incriminating odors. You'd be surprised how many cases we have about that. The list could go on and on. Just understand that when we look at these statutes and observe definitional aspects, we begin to see where some strengths and weaknesses could be within the scheme. Now, with respect to probable cause or reasonable suspicion determinations, 4609 comes back and gives us a little bit of the things we didn't get from those definitions. Arguably, what it states is that the race, ethnicity, national origin, gender, or religious dress of an individual or group shall not be the sole factor, again, sole factor, in determining the existence of probable cause to take into custody or to arrest an individual, or in constituting a reasonable and articulable suspicion that an offense has been or is being committed so as to justify the detention of an individual or the investigatory stop of a vehicle. Okay, we got some stuff back in 4609 that we didn't get in definitions. Why is that important? Well, at least we can say that we have some aspects in 4609 that I said might be missing. The problem is that when we get to the next section, which is when does an individual have a right to sue when he or she has been the subject of racial profiling, 4609 is not where we look. We're back to the definitions. So there you are again, perhaps something we could talk about later. The sole remedy under 4609 is apparently parallel to the Fourth Amendment and the exclusionary rule. And it does include stops and seizures, but question, does it really give us very much beyond our current jurisprudence in Kansas as we look at reasonable suspicion or probable cause determinations? We might talk to some of the judges about that. Now, finally, I just want to mention the remedy beyond what I just mentioned, but a remedy in terms of an ability to go after a law enforcement officer who's engaged in this practice. What can a victim of racial profiling do? That is outlined in 4611 of our scheme. And currently it says, any person who believes such person has been subjected to racial profiling by a law enforcement officer or agency may file a complaint with the law enforcement agency. Okay, so you can file a complaint with the local police department, for example, if you believe that you have been the subject of racial profiling by a member of that police department. The complainant may also file a complaint with the Kansas Human Rights Commission. So you have an election under the statute. You can go either way. The commission shall review and, if necessary, investigate the complaint. The commission's designee shall consult with the head of the law enforcement agency before making final recommendations regarding discipline of any law enforcement officer or other disposition of the complaint. And then Section B, upon disposition of a complaint as provided, in other words, whether you lodge a complaint with the law enforcement agency or the Human Rights Commission, you then shall have a civil cause of action in the district court against the law enforcement officer or agency, or both, and you'll be entitled to recover damages if it's determined by the court that such persons or agency engaged in racial profiling. And the court may allow the prevailing party attorney's fees and court costs. But again, under this remedy statute, you have, I would argue, some of the limitations of the definitional sections that I that I began by overviewing for you. We also have within the statute some other provisions that are of interest, and we can come back to those, but I don't want to take up too much time. We have a reporting requirement for local law enforcement to report on complaints that have been filed against their agency. We have some excellent monitoring provisions. I would note I'm not very familiar with the extent to which racial profiling complaints have been filed because none of these cases, no civil action, no civil cause of action has yet made it to our appellate courts. And therefore, we have never seen one of these cases. Obviously, it's a fairly new statute, 2005, but we note from a recent statistical report that there have been a number of complaints filed at the local level. It's unknown to us, and maybe someone else on our panel can talk about what has occurred with the Kansas Human Rights Commission. I just want to mention briefly that to the extent that I have raised questions or indicated there may be some weaknesses in this scheme, I note that in this year's legislative session, a bill was introduced, Senate Bill 610, which would have addressed some, if not all, of those weaknesses. That bill did not get enacted by the legislature, and I am not familiar with the detailed history of what happened there. I think someone else on our panel will be talking about that, but understand that there has been an effort made to perhaps tighten up our statutory framework a bit on racial profiling, and I think you'll hear more about that from some of my colleagues here on the panel. So in summary, racial profiling is indeed illegal in Kansas, no question. And that's the good news. Remedies are provided. Indeed, that's the good news. But I would suggest perhaps there are some overall weaknesses in the statutory scheme that we could talk about further to the extent that you have interest and we have time. Thank you very much.
Thank you, Judge. And your permission, I'll keep with the judges because I have to appear in front of them. Okay. Judge Kaplinger?
Oh, okay. Okay, that's fine.
If you want to do it the other Judge Green, I don't care.
Well, Nancy wanted me to go. So,
Okay.
Seniority
Okay.
first.
As Judge Green, Richard Green has talked to you about, there is against the law. In most jurisdictions, you're going to find statutes that say racial profiling is not legal. But the big problem is well, I will talk to you about a criminal case, and it's a recent criminal case from the Supreme Court of Massachusetts in this Commonwealth versus Laura. And let me give you the site on that. It's 451 Massachusetts, 425, 886 Northeast 2nd, 688. This case came down May 20th of 2008. Very interesting case. Many of these cases that we start to see, they are involved in the criminal area. And what we had here in this particular case, we had a Hispanic defendant who was on Route 290 in Massachusetts. He just was going through a community called Auburn when he was stopped. A highway trooper later was able to search his vehicle, found his vehicle contained cocaine, a large amount of cocaine. He was arrested. He filed a motion to suppress the cocaine. And one of the interesting things, which doesn't happen that often, at the trial court level, where he presented his motion to suppress, his attorney had gotten together statistics. Generally, in these cases, you have to have statistics. This officer had cited in the Auburn area like 51 citations that he had rendered. And of the 51, he had cited Hispanics over 30% of the time. When you looked at Auburn's population, the census from the 2000, their census as far as in Auburn was 97% white, okay? The Hispanic population was 1%. Well, the trial court judge was he was influenced by the numbers and saying, here, you know, a Hispanic person is likely to be stopped, 31% higher than what they should be stopped based upon their population. So at the trial court level, a trial court judge suppressed the evidence. Well, the state wasn't happy with that. They were very upset with that, and then they filed a motion for reconsideration. They brought in PhDs in statistics with their own figures, and they had a motion for reconsideration, which was heard. During the motion for reconsideration, some of the PhDs who looked at the statistics that was initially used in the motion suppressed and say, well, they're slanted, they're distorted. What you need to have here is that you needed to have statistics showing the people who travel on Route 290 near Auburn, what is their makeup, okay? And if their makeup, we need to find out how many Hispanics, how many blacks, how many whites travel in this particular area. Make the long story short, that it went to the Supreme Court of Massachusetts, and they found that the statistics were in error because when you actually look at the statistics, and then when you went to the officers' citations, of the 51 citations that he had issued during this period of time in the area, 90% of the citations were issued to people who did not live in Auburn. And that was the key to them as far as the Supreme Court saying that we can't accept these statistics. And as a result, the Supreme Court set a very, very high burden. I don't want to take up too much of your time. And this is what makes it so difficult for a defendant to show racial profiling in these kind of cases. And this is what the court says that you have to show. It's a triple burden. That the defendant, in order to meet his burden, the defendant must first present evidence which raises at least a reasonable inference of impermissible discrimination, including evidence that a broader class of persons than those prosecuted have violated the law. What that would mean is that you have to show people who the officers would not generally stop, which in most cases are white individuals. You have to be able to show that category, saying that these are people who go through the area, violate the law, but yet and still are not being stopped by an officer. What a high burden. And then they went on to say, and that the failure to prosecute was either consistent or deliberate with discrimination. And finally, that the decision not to prosecute was based on the impermissible classification such as race or religion or sex. So in these kind of cases that we're seeing now in other jurisdictions and in the federal courts, there is such a terrific high burden placed upon an individual to show statistically that they are being discriminated against. Thank you.
Thank you. Now, Judge.
In our court, we always go by seniority, so I felt out of place talking first because I'm way down on the list on seniority, as you might gather. First of all, thank you very much for the invitation to participate in this event. We are, the three of us, as well as our counterparts in Topeka, there are 13 Court of Appeals judges, and we're extremely collegial group, probably because we travel together 2 days, at least 2 days out of the month, sometimes 3 days, and we spend about 18 hours a day together, so we get to know each other really well, and we don't seem to fight about anything. Well, it's all very friendly fighting, at least, but when it comes down to who gets to come to K-State for Constitution Day, there's some disputes going on. So I don't know how I got lucky, but this is my second time here, and I'm really thrilled to be here. Not being a K-State grad, I think I had to bring cookies or something to get the chief to put me on the panel, but I'm very happy to be here again, and this is a great topic and a fascinating topic. The judges Green and Green here have talked about a few of the things I wanted to mention, and in particular, I want to talk about the difficult burden it is right now to meet the prima facie case in one of these racial profiling, either as a defense in a criminal case or on the civil side in some sort of 1983 action. It's exceedingly difficult, although I want to talk about a couple of Kansas cases where I think the courts have are trying to deal with some of the difficulties and are being a little bit more permissive when it comes to statistics and what they might be used to show. Before I do that, however, I want to talk about, as Judge Richard Green said, we don't have any cases pending in front of us that we're aware of, so we don't have to worry about talking about anything, and we're not aware of any Kansas appellate cases that really have racial profiling as a primary issue. But my research attorney, in doing some work for me today on this, she came up with an Attorney General's 2007 report on racial profiling that I thought was kind of interesting. I didn't know was out there, and I'm sure Kyle probably does know about this, but it's available on the Attorney General's website. And it lists literally every single law enforcement agency in the state of Kansas individually, city, county, college law enforcement groups, and it indicates the number of complaints that have been filed against them, racial profiling complaints, and what's happened with those complaints, if they were investigated, if there were any findings. And I was quite amazed. I didn't add up the numbers, but there are a number of complaints, and so I guess at various stages of being investigated. Of course, they're heavier in the more populated areas, but I'm amazed at the number of complaints in rural areas, or maybe I shouldn't be amazed. But in any event, I think we probably will see some of these cases in our court down the road. And so those statistics are out there if anyone wants to know what's going on right now, at least in Kansas as far as complaints being filed. Richard talked about how this issue comes up in the court. It comes up in, like I said, in civil cases, and there's been one Kansas case I think was pretty interesting. I'm sorry, it's not a Kansas case, it's a 10th Circuit case, where there is something in that case that is very not typical in these types of cases, and that is they had direct evidence of racial profiling. It was a civil case brought by an individual who had been stopped by the police, arrested, subjected to a blood test at the hospital. He ended up being released and not convicted of any charges. But he then filed this case alleging unlawful arrest under the Fourth Amendment and bringing 1983 kind of action against the hospital as well as the police officers. In this case, the district court dismissed it, saying, well, there's really no evidence, essentially, of any fact issue about racial profiling. But in fact, the 10th Circuit, which is our appellate court in Denver, said, no, there's quite a bit of evidence here of direct discrimination. And the kinds of things that court looked at and said was direct discrimination is interesting, I think. They said that this officer, first of all, he pulled up to this individual's vehicle and ascertained his race before he ever stopped him. He then made repeated accusations to this defendant that he was on crack, suggesting he was on crack, before he ever told him what he was being arrested for. He made an unnecessary notation on the police report that this individual was a black male in an area that wasn't, in a spot on the report that wasn't asking for race. It wasn't relevant. Also, very interesting, this officer changed his story dramatically, the court said, from the time of the incident where he arrested this person and later on in court when he filed his affidavit. For instance, on the police report, he said that this guy accelerated to 100 miles an hour and did various things that got his attention. He completely forgot about some of these egregious things later on when he did his affidavit. And even more, the court said if that's not enough, there's even more. This plaintiff presented evidence that this particular officer had been fired from his prior employment in Texas as a police officer in Texas. He's now in New Mexico. And there was a memo they had found that said he was fired for failing to treat people fairly and equally under the law. So the 10th Circuit said, no, we think there's plenty of evidence to say that this should not have been, summary judgment, which is basically a dismissal on the facts, should not have been dismissed, and we're going to send it back to the court to proceed to trial. And I'm not sure what happened, to be honest with it, after that. I don't know if Kyle does.
Nope.
But I think that's a fascinating case from our own circuit. Kansas is in the 10th Circuit, indicating that if you have things that combine a lot of factors that might seem small by themselves, but taken together, you might actually be able to make a case of racial profiling, at least a civil case. Another case I would like to talk briefly about is one that I was involved in. I have kind of a unique perspective on this because I wrote the brief in this case, United States versus James, back in 2001. It was one of the first cases published by the 10th Circuit on racial profiling. Do you remember this case,
Yeah.
Kyle? Yeah. It was 3 defendants, actually, who claimed that the Topeka Police Department and the HUD investigators, there was a team that they put together, that they targeted only black crack cocaine dealers and ignored similarly situated white crack cocaine dealers. I think there were like 26 arrests or so.
It was a big case.
It was huge, yeah, it was huge. And these were some of those defendants. They also argued that the U.S. Attorney's Office treats black crack cocaine defendants differently. This came about, and it's kind of a complicated setting, but it came about on a denial of a motion to obtain discovery on selective prosecution. In any event, Henry's told you how difficult it is to prove, and I think it became very difficult for the defendants in that case. They actually did come up with some statistics, but it wasn't enough. And let me tell you a little bit about those statistics. They had statistics showing that 100%, 97%, and 67% of those arrested as a result of the investigation were black in these 3 different complexes, and 92% of the crack cocaine defendants represented by the FPD, the Federal Public Defender, since 1999 were black. They compared this data, so they had testimony showing the crack cocaine defendants and those arrested were primarily black. They compared this data to testimony from a local drug counselor in Topeka who said that persons who voluntarily commit themselves for treatment for cocaine addiction were generally 50% white and 50% black. They also pointed to a study showing crack cocaine users frequently rely on drug sales to support their habit. So the point was, they were trying to draw a correlation between the fact that those seeking treatment frequently were selling cocaine, and they were about 50-50 black and white. And yet, a very heavy prosecution of black defendants, at least with respect to crack cocaine. Well, the court rejected those statistics. They said the defendants didn't satisfy that discriminatory effect prong that Judge Green talked about. They said that the evidence shows, let me see, as I recall, they said the drug counselor didn't distinguish, the drug counselor who said it's 50-50 people in treatment for cocaine, she didn't distinguish between between crack and powder cocaine, and so she didn't really prove, or the defendants couldn't really prove that these individuals were similarly situated to the defendants. So that was the main reason, I think, is that they didn't, while they had these statistics, they couldn't come up with statistics showing that there were similarly situated white individuals who were not being prosecuted or investigated, and that was the problem in that case. I also want to mention something interesting about that case, and Kyle might remember this. In representing the Department of Justice on that case, it was the most difficult brief I ever wrote, and I wrote a couple hundred briefs there, but it was by far the most difficult because the Department of Justice anytime one of these racial profiling cases comes up, and they don't come up frequently, but enough, there's been a few in the District of Kansas, the Department of Justice requires that we get approval of our brief at the highest levels of both the Criminal Division of the Department of Justice and the Civil Rights Division of the Department of Justice. It was the only time I wrote a brief that had to be approved by two different departments of the Department of Justice in Washington, D.C., civil and criminal. And that was because the Department of Justice, of course, wears two hats in that regard. And I actually appreciated that a lot about them. And it was extremely difficult because they were literally, both departments were weighing and balancing every word to make sure that it didn't conflict with either side's or either one of their goals or their priorities and didn't say something that they couldn't agree with. So it was difficult to write, but I guess I'd just like for you to know that the Department of Justice does take these things very seriously, and they don't necessarily. In other cases, it's purely a prosecution issue, it's purely a criminal division issue. In racial profiling cases, it's a civil rights issue as well. The cases I found most interesting, I don't know if I've got a couple more minutes, are we okay? You can cut me off, you can cut me off. The cases I found the most interesting, I think I made some notes about, and Kyle again is probably familiar with these, are two cases from two different Topeka federal judges. Both involving traffic stops by the same deputy out in Russell County on I-70, Deputy Schneider. They both involved Hispanic defendants, and in both cases, they attempted to prove racial profiling, that they were stopped not for a cracked windshield or speeding, which was the two different things that these two individuals were stopped for, but that they were stopped because of their race, Hispanic race. Both defendants used the same statistical study, but the court came down different ways on it, and I think this is interesting as to why. They used this study called the Lambert study, and Kyle knows about this, yeah. It was commissioned by Governor Graves. It surveyed traffic stops during 4 months in 2002 throughout the state of Kansas, well, actually in 7 different law enforcement areas. The particular aspect of the study that was interesting in this case was a stretch of the highway I-70, some of you have been on there, between Colby and the Colorado border. That was one of the areas that was studied. Well, this particular Deputy Schneider, doesn't patrol between Colby and Colorado. He patrols in Russell County on I-70, but he does patrol I-70. But they were using statistics generated from Colby to Colorado. And those statistics showed that the transient population, meaning the population traveling across Kansas on I-70 in that particular stretch, is 2.6% black and 1.8% Hispanic. Pretty low percentages on the transient population. The Kansas Highway Patrol initiates traffic stops on that stretch of the highway that are 5.7% black and 6.8% Hispanic, a little bit higher. Then they came up with this evidence that showed that Deputy Schneider in Russell County, not on this stretch, but very near this stretch, his stops were on the average 56% white, 33% Hispanic, and 9% black. So his stops were 33% Hispanic, while the transient population across that general area was 1.8% Hispanic. And they used this to show, attempt to show the discriminatory effect prong of racial profiling. Well, Judge Robinson said, well, of course, the argument was against it that these couldn't be similarly situated, and that first of all, that this study was not relevant because it was a different area. It was down the road from where they did their study. But Judge Robinson allowed in evidence from someone who said, well, it may be down the road, but the fact is the transient population is about the same in Russell County as it is in Colby and down west of there. And so she allowed them to basically extrapolate that information and say, that's enough. The problem was the second prong, which is you don't just have to prove statistical evidence to show discriminatory effect. you also have to show discriminatory intent. You have to show that the government's enforcement of the traffic laws was invidious or in bad faith and based on impermissible considerations. This is very tough. In fact, I didn't even find a case where they met that standard. And Judge Robinson said, we can't use those statistics to show that intent. And as long as that's the case, it's going to be really hard to get past that particular prong. However, interestingly, Judge Crowe, using those same statistics in a similar case, said he wouldn't even allow those statistics to meet the discriminatory effect prong. He said, no, I don't think that's good enough. Those statistics are irrelevant, he said. They're unreliable, and that's because they don't cover the same general geographic region. And he would not agree that the fact that it was just down the road was sufficient. So he was a lot tougher on that, and that's not really uncommon. So I guess the point I'm trying to make is it's pretty hard to get there. I wanted to point out a footnote at the end of a 10th Circuit case where they rejected some of these statistics. It was actually the appeal of Judge Crowe's opinion, the 10th Circuit affirmed, and they said, yeah, it doesn't meet the discriminatory effect prong, but they said they found the statistics disturbing. And they assume that in the future, federal prosecutors will take the utmost care to assure themselves that racial profiling is not lurking behind such statistics. I think that was probably the best the court thought they could do in terms of saying, we don't like this statistic that says 33%, an officer stops 33% Hispanic stops when, 3% of the population, transit population is Hispanic. But we can't really do anything about it until you get it in whatever that right format is. And I'm not sure. I think perhaps, somebody will figure out a way to get there. The real problem is, how do you show that similarly situated, in this case, white individuals are not stopped when no departments keep evidence of people they don't stop? I mean, the courts have recognized this over and over. It's almost impossible to show in a traffic stop situation similarly situated individuals who weren't stopped. They're out there, but how do you know who they are? Do you park yourself at a traffic corner? And some of the courts have actually talked about this. How do you get there? And so I think that's the issues the courts are facing right now, and it's difficult. It's difficult.
Thank you, Judge. And has this table made any decisions as to who goes first? Okay, we need to move this along, folks. Come on.
Actually, I think, my background, I did work in NHTSA, National Highway Traffic Safety Administration, and that's where these grants actually have originated. But I kind of came across, or really became familiar with the term racial profiling back in 1992 in Washington, D.C., and of all places, I became familiar with it playing basketball, and on a T-shirt was Robert Wilkins. Played for about a few hours, and I finally asked the kid, well, who's Robert Wilkins? He said, oh my gosh. Robert Wilkins was a gentleman who lived and worked in Washington, D.C. And in 1992, he and his family were driving back from a funeral of his grandfather's from Chicago. When they got to the state of Maryland, almost home in Washington, D.C., he was stopped. He was a Harvard-educated attorney, and so he knew a thing or two about a thing or two. And the police wanted to search his vehicle. He said, no, you're not going to search my vehicle. Well, they proceeded to take he and his family out of the vehicle, search the vehicle, humiliate them as they were standing in the rain, and car after car went by honking or doing what they were doing. Well, again, after this, he went and contacted the ACLU, or they contacted him, or he filed a suit, and the rest is history. Racial profiling, that term had come to be. But racial profiling, we hear, a lot of things that we're working on. I kind of have a policy background, and what's going to happen is we are going to tighten up, the legislation in Kansas, and things are going to happen. But racial profiling has occurred. I don't think any of us have to mince words, has occurred in this country since slavery. and only has it really started affecting the Hispanic community as of late. And then back in 1999, 81% of Americans, white, Hispanic, and otherwise, agreed that racial profiling was wrong and occurred. Had a little bit of a setback after 9/11, because 60% of Americans believe that racial profiling was a legitimate way to conduct and do business. You know, that being said, we've heard a lot of things from the judges as far as what we can do as far as combating racial profiling. And the three ways that we work within our office is through, you know, obviously litigation and legislative lobbying, you know, hearing from citizens. I probably get somewhere between 5 and 10 calls in my office a week. Recently, one from a Hispanic woman in Wichita, Kansas. I don't know if any of you may or may not know the extensive background that one has to go through to sell or be an insurance salesperson. Well, this woman had done that, found out that her ex-husband had gotten a parking ticket back in 2003. Their judges, the police officer was legitimate in arresting her in handcuffs. She actually had a 6th grade girl at home, did not know where her mommy was from 3 p.m. until 11. You know, in all cases and scenarios, we know that that's not wrong. Were the police officers right according to the law? Can they do that? Yes, they were right. She probably, had she known about the ticket, she would have done it. But, you know, these are the things that occur. I mean, in our community, the things that we hear, when are these police officers going to remember the service part of serve and protect? And those are the things that we're trying to work on. You know, as being a member, not a member of the task force, but being part of the administrative part of the racial profiling task force, I can tell you that, you know, we have a group that has worked together, very successful, and successfully, I think, and is doing everything to bring the community response as far as when they draft and craft this legislation. And hopefully over the next year, I'm pretty confident it'll come out of Senator Brumgart's committee, who's from Salina, very, you know, a person who believes very strongly in good government. I think that we'll have a piece of legislation that will have some teeth to it, and we'll get more than I think it's. We've had no convictions on racial profiling. We've had, to this date, I don't think any police officer has lost his job. And I don't think anyone in here would leave here tonight saying that racial profiling does not occur. It occurs on a daily basis. And, you know, unfortunately, we've got to do everything we can to make sure that it doesn't happen again, because sooner or later it's going to happen to a member of our family, because, you know, everyone in this urban culture goes to school, goes to church, and works along someone of some different or darker hue.
I don't talk very loud, so I'm hoping can you all hear me okay? Move this a little bit closer. Is that better? Good, good. I actually had the chance to work with Dorothy Thompson when I was here in the Equal Opportunity Office here. Well, it's Affirmative Action Office here at K-State. So I'm really excited to be here and have the opportunity to participate in this lecture series. Thank you very much for the invitation. I'm also really excited for the chance kind of to go back to school for just a minute and hear the judges' opinions on our statutes. We should have thought about this a long time ago, and I should have trotted across the street and brought these to you and gotten your input a long time ago, and maybe these would be very different. What I'm going to try to do is really marry what the judges have talked about from the legal premise and the constitutional law, and what Steve just talked about in our role in terms of being community advocates and being supportive of the community efforts to eradicate profiling. And I think say what's most difficult about addressing the issue of racial profiling is because it's one of those problems in our society that you just can't address in legal terms alone. And so how do we craft statutes that provide the constitutional right and allow police to do their jobs and to engage in their work and use the standards of articulable suspicion and probable cause and still serve and protect the community in a fair and unbiased way? That's really what our challenge is. The problem is that the perception, particularly of the minority community in Kansas, is that police are not respectful of their civil rights. There is this fundamental breakdown in the trust of minority communities with law enforcement leaders and law enforcement agencies. And I keep telling the law enforcement leaders when we meet with them, the problem is that you as leaders have to find a way to go back out into the communities and get people to trust you again. When you can rebuild this trust, then we can really start to use the legal tools we have available to eradicate racial profiling. And I just feel strongly that until we do that, a lot may not change. Steve and I are often reminding law enforcement leaders about our history, because again, that's where this is rooted. We have this 100-year-old history of slavery, involuntary servitude, lynching, Jim Crow laws, and then really I think the general public's lack of understanding of what a law enforcement officer can and cannot do when you're stopped on the road. How many of you know that if you're stopped, you do not have to give permission to search to have your vehicle searched? But sadly, most people don't know that. Unless that officer has a reasonable suspicion, or there's some contraband in plain sight, in plain view, or some reason to believe that a crime is being committed, or that you've otherwise engaged in some action of breaking the law, that they can ask to search your vehicle, but you don't have to give permission for it to be searched. And so I think, again, there's this fundamental breakdown of public knowing what officers can and cannot do. Really, we are challenged in Kansas because the study that Judge Kaplinger mentioned did show that in the 7 areas where we studied profiling on Kansas highways, I'll just read to you the summary of the officers who conducted the study. They said their findings confirm that the state of Kansas is experiencing profiling of Hispanic and Black motorists. And while evidence was not apparent in all jurisdictions, 7 of the assessed agencies had evidence of at least one of these 2 groups being targeted by police in traffic stops, sometimes more than 5 times more likely to be stopped than Caucasians on Kansas roads. All 10 agencies assessed in the report were asked for alternative explanations that were considered, and the researchers could not find any existing evidence that supported the assertion that the members of minority groups were more likely to violate traffic laws. So this research confirmed that we have profiling going on. It's the what to do about it and how to address it where we have been most challenged. I think the most important thing that we've done, though, to address profiling is bringing together the Governor's Task Force on Racial Profiling. It's a group of law enforcement leaders, a group of NAACP presidents. Can you imagine this? The police chief in Wichita and the NAACP president in the same room. We have some amazing discussions and some amazing meetings about how we're going to go forward in Kansas. And I tell you, that's made a huge difference. We've worked together on redrafting these statutes, and we're going to continue to do that. And I think law enforcement agencies have learned from communities and communities from them. So really, that's been our most important effort. Our second really, effort that I'm really, really proud of is the federal National Traffic Highway Safety Administration made $7 million available to states who were working on eradicating racial profiling, and Kansas has received $1 million of those dollars. We need to continue to work with you and figure out how we're best going to use those dollars to prevent profiling. Are we going to invest all of it in training of our law enforcement officers? Are we going to invest it in data collection, where we are counting every single person who stopped, keeping data on every individual who stopped on Kansas roadways, how they're stopped, who stopped, what time they're stopped, everybody, and then utilizing that data as a management tool, as a tool to prove or disprove profiling in court? Are we going to collect it? Are we going to use it? Or are we going to invest in purchasing cameras? The Kansas Highway Patrol has cameras in almost every single one of their vehicles, and they feel like that's an important tool to be able to monitor how their officers are engaging people on Kansas roadways. But there are several law enforcement agencies that don't have cameras. They don't have any other means of assessing how law enforcement behavior happens out on the roadways. Steve and I have been to a company in Kansas City that sells a combination camera, and it's a digital tool that allows all of the data that's kept with the camera to be downloaded to a server and then to be able to be used by the law enforcement agency thereafter. So every time they stop somebody, the camera data is recorded digitally and saved on the server so that they can recall that data later. So the officer doesn't really have to do anything but turn on their camera and utilize it. All kinds of creative and amazing things we can do, and we've got $1 million. We've got to figure out what to do and move forward as soon as we can, and we're just working hard in that effort.
Thank you very much. I'm assuming there's no questions from the audience at this point in time, so I'll go ahead and launch into.
I have a question.
All right, go ahead. We have microphones down here if you want, or you seem to have a good voice.
Yeah, I think about here. Kind of have one question, and I'll kind of put some background behind it. If statistical relevancy is determined, why do you still have to prove intent? And I say that because I've come to learn from taking diversity classes at K-State that a lot of times people who discriminate take part in discriminatory actions don't really know they're being discriminatory. Because you ask them all day, like, I'm not discriminatory, I'm not discriminating, but if you look at their history, it shows they take part in discriminatory actions. So if that holds true with a university or any other institution, why wouldn't we hold that same account true to our police departments? Like if an officer, and I kind of agree with you. I think every officer traffic stop needs to be dictated, notated, and there's statistical relevancy put on it. And if an officer is too high in one area per capita, they need to be called in question. So with that being said, if you can prove it statistically, and with anything else, if you prove it statistically, it's legit. Why doesn't that hold true for our police department?
Good question. Does anybody? That's maybe more of a judge question, actually. Do you want to explain the court's reasoning on that?
Well, I think you have to have the discriminatory intent prong, or otherwise you wouldn't have, in order to have a violation of your constitutional rights, you can't simply show an effect. You've got to have the reason for it. It has to be motivated. In this case, racially motivated. Otherwise, if you could just establish your case, a constitutional violation in this case, by showing just a simple effect, you wouldn't take into account the possible reasons for that effect, if that makes sense. I think where you're getting at, and it's just an excellent question. I think it's one that, like I told you, I think it's frustrating the courts. I think where it needs to go is a way to figure out how to use that statistical evidence that's allowed to prove discriminatory effect to also create at least some kind of inference of discriminatory intent, perhaps. And when it comes to that particular individual officer like this, and I think that's what you're suggesting, is if one particular officer is shown to be arresting any minority group in a much higher percentage, why isn't that evidence of that particular officer's intent? And I think that may be where the courts are going. I think they've gotten a lot looser on the effects side. Some courts have said statistical evidence isn't even enough to show effect. So that's an exceedingly good question, I'd say.
Can I just add? I think the problem we see as judges, when you have a police officer, if he stops you for a traffic violation, and it's clear it's a traffic violation, what you're dealing with is supposedly good faith on the part of that officer. And to get around that good faith, you have to show this type of intent. And so the officer is built into the system that if the officer stops and it's a traffic violation, he's doing this in good faith. And in order to overcome that, then you have to be able to show discriminatory intent.
One of the tools.
Okay.
I'm sorry.
I guess I'm the moderator. You go first.
One of the tools that the task force has talked about utilizing in Kansas is what's called an early warning system. And this allows law enforcement leadership, the captains, the chiefs, to use the data collecting tool to make an inference that if the data shows that their officers are behaving in a way that may show disparate treatment or disparate bias policing in some way, that the chief then can use that data tool to discipline the officer internally. And they actually are pretty excited about that notion. Now, whether we make that codify that and make that a part of statute where we sort of demand that or mandate that police chiefs in Kansas use such a tool, that's been discussed. But that's one of the ways that you could use the data and use it internally to manage the behavior of your officers.
I just think it's important. I think it's an excellent question also. Let's be sure we understand the difference between bringing an action under the federal Constitution in a federal court, where you have to face this judicial test that the federal courts have said you have to show the effect and the intent, versus bringing an action potentially under the Kansas statutes 4611. We do not find, at least codified in 4611, these two prongs that would have to be shown. We have instead the need to establish racial profiling. There's probably enough latitude there for some appellate court to try to figure out what the legislature meant, but we're still stuck with the definitions that I went through earlier. But understand, there is a difference whether you're bringing that case under Kansas statutes or under the federal Constitution in a federal court.
While we're on statistics, I remember the 2002 Lambert study. Emporia, Kansas was determined to have a disproportionate high stopping of Hispanics, probably more so than any other city in the state, which on its face, again, appears to be a pretty clear case of racial profiling. The chief of Emporia, Kansas at the time, Bobby Joe Rodriguez, and the underchief, Mike Lopez, explained it that they were trying to focus the enforcement areas on the Spanish part of town that had the gang problem. So you may have statistics that clearly show that there's a disproportionate number of stops, but you also have to look to see whether there may be explanations, rationalizations, things like that.
Which is another reason why they like the early warning system, because then they can look at whether they've had a special drug interdiction task force in a particular area, or if there's some other effort, I guess, by law enforcement to target a community that might skew those statistics. And that way, they're using it internally. They can measure the results based on that information because they have it.
Statistics are a very complicated issue, which is why the Commission's been working hard for about 3 years now. Topeka, Kansas, where I'm now working, we've got it divided into 3 sections. One section has a vast majority of the black population in it. So if you try to compare the officers in the East Topeka versus Southwest Topeka, yeah, you're going to have a disparity. So you have to take those kind of factors into consideration, and it gets very complicated. That's why people like you study statistics at college, to help us down the road. Okay. Yes, sir. I was told nobody's going to ask any questions. Okay, go ahead.
Is it a pretty standard state legislation that they agree on racial profile legislation, or is that basic premise kind of debated among states? What I'm asking is, do most states have racial profiling laws? Is even that basic premise disputed?
22 states.
22. So not even half.
Yeah. Now, I might point out that Supreme Court, and I could ask the judges there, why do we need statutes if we have 1983 actions, we have the 14th Amendment, we have the 4th Amendment? If it's already banned by federal law, does the state law add anything in addition?
Well, some of these actions, I don't know how much of this to go into, because we talk differently when we're speaking to a group of lawyers or law students than we do to you, and I don't know how interested you are in this, but most of the civil actions alleging racial profiling are Section 1983 actions, and they have to be, in order to, there has to be state action for those actions to proceed, and then so they sue sometimes the police department because they're state actors, and so that's how they can get the constitutional claim in that way. And they try to bring in private entities that way too. For instance, the case I mentioned, they tried to bring in the hospital because sometimes they can get a private entity acting as a state actor. Anyway, I think one thing, it's very difficult to bring a civil action against a private entity. You've got to come up with some kind of a state law tort claim, which is difficult. So I think these racial profiling statutes will broaden the remedy by far against private, I would think.
Well, our
Well,
statute
no, it
says
wouldn't, would it?
government
It says
agency.
it's limited to law enforcement, that's true. And I don't know, maybe, are there other states that have anything broader than that? As far as against a private entity? Because that's the hard thing to get to.
Yeah.
I don't think so. Of the ones that I've read, they're specifically really geared towards the actions of law enforcement,
Law enforcement.
and to prevent, I guess, unlawful acts on behalf of law enforcement.
Well, this is why this subject does belong in the Federal and State Affairs Committee of our legislature, because indeed, as we've pointed out, you've got some overlap between federal and state law here. I guess the answer to the question ideally is that you would have a statutory framework that indicates a legislative intent to make this a high priority, and that the standards of proof and the ease of remedy would be different in the state level by statute than it is at the federal level. And whether our legislature decides to do that or not is beyond the discussion tonight. I'm interested, however, along that line, if I can ask a question of Danielle. I mentioned Senate Bill 610. I'm not sure what happened. It looked like it really would have made some improvements to our statutory scheme. What happened to it this year in the legislature?
Senate Bill 610 was introduced by Senator Donald Betts from Wichita. Many of you may know that the city of Wichita has had a long history of issues with their police department. I'll just put it that way. And so really our statutes grew out of their concern about the whole state and their city of Wichita. He introduced it to the Committee on Federal State Affairs. And what we really wanted to do is, one, continue the work of the task force for a period of years, hopefully 2015. The other thing that we really wanted to do and to make a change to our statutes was to look at our definition and to possibly remove the word soul, so that using race, if an officer should use race to any degree in determining who to stop, would be prohibited. So that they really had to rely on the other rules regarding police work. If they weren't looking for a person with a particular description, then they couldn't use race as a factor. We also wanted to mandate the use of a uniform traffic citation. One of our challenges in Kansas is that every jurisdiction has a different traffic ticket. So when you're trying to collect data, we just found to do it in the way that we'd have to really start over in how we issue citations in order to collect the data about who was stopped and how they're stopped and what happens after the stop. And we'd like to have one ticket that's used all over the state, collects all the data. It's stored in one place, and then all state agencies could extract data that they need for lots of different purposes. So that was one of the other things we wanted to do. We also wanted to add an additional review of law enforcement agencies. As Kyle mentioned, he worked with Kansas Seapost, and that's the agency that disciplines law enforcement officers in our state. We wanted to allow them, once a determination had been made by the Kansas Human Rights Commission, to be able to have that determination reviewed by officers who discipline officers to make sure that if any further discipline was warranted, that it would happen. So that was another important addition.
Let me follow up on that point and a comment you made in passing that this could be a point of emphasis for the legislature. And I'm playing my devil's advocate role as moderator. Why is racial profiling more severe than police brutality or other things that officers are punished for? Why do we have to have this separate mechanism for this malfeasance when if we have an officer committing illegal search and seizure, violating people's other rights, C-post, civil cause of actions, criminal prosecution seem to work. Why is it that we have to have this special system?
Because people were adamant that this was a particularly egregious abuse of their constitutional privileges, and they wanted to see that addressed.
More so than being shot?
Well, not necessarily more so, but I think they wanted to at least make it equal. I think they feel like they can get redress if somebody's shot, but they don't feel that they get redress when they're stopped on the side of the road for what they believe to be no reason for several hours, and so they wanted to make it as important.
Which comes back to the courts. I think that's how we ended up with the exclusionary rule, is that the courts held that suing the cops for an illegal search or illegal interrogation was not adequate because nobody really cared whether a rapist collected money or not. So the courts came up with the proactive rule that we're going to just throw the evidence out and not allow the cops to use it. Why haven't the courts taken any proactive, and I may be regretting this someday when I'm arguing the other side of this, but do the courts feel any responsibility that if this is a problem, this is something they're seeing, why do not the courts take that proactive action like they did with Miranda or exclusionary rules?
First of all, I think the exclusionary rule does play a role here. I mean, where you're headed, it seems to me, particularly with 4609, or an allegation of racial profiling in having been the basis, and I agree, you need to get that soul word out of there, but if it was a basis for the stop, the exclusionary rule is going to kick in. I mean, it's going to provide a remedy under 4609 or under the federal Constitution, for that matter. It would be the rule. Now, for us to come up with some other remedy, you know, we like to stay away from activism in that regard. Anybody want to add to that?
Well, the Massachusetts case, Massachusetts Supreme Court came down. The exclusionary rule does apply, and this is what they say. If the defendant can establish that a traffic stop is a product of selective enforcement predicated on race and thus violative of the constitutional right to the equal protection of the laws, evidence seized in the course of the stop should be suppressed under the exclusionary rule. So they're saying that we will suppress it, but you got to prove your case.
And the intent. Follow-up question.
So, what if a person is stopped based upon their race, but another infringement is found, whatever it may be, and then they're detained based upon that? Doesn't that make the initial stop that much harder to prove? Even if it was the case, like if there was no infraction prior to the stop, that's one of those, I mean, to me, kind of seems with the current system, it seems like that's just the gray area where you get stopped because you're black, but since you did something, it doesn't really matter.
Pretextual stops are
Well, I think he's talking the opposite of pretextual. Pretextual is where you stop somebody for a legitimate reason, but you may have another reason for actually interviewing them. He's saying you have no reason at all to stop them other than the fact they're a person of color.
But they make it up later?
Or female, or ethnicity. Or,
Whatever it may be, but
yeah.
along the lines of that stop, they find something, get a suspended license or paraphernalia or an open container, anything. And then they follow the steps are followed from that
It would be
due
hard not
process,
to
but
prove
up until
properly.
that point, due process wasn't followed.
You're stopped because you're
He's racially profiled, and then he finds some
the
contraband.
handgun in the
Would
car.
that be
Right.
grounds for fruit of the poisonous tree argument? Saying that the initial stop was illegal, therefore anything that proceeded from that should be
Well,
suppressed?
You have
You're correct,
to prove it.
because that's the way they have been attacking. If you can prove the stop was illegal, then whatever they find later is a fruit of the poisonous tree and should be suppressed.
That goes back to my initial
The question is, how do you prove the
You
stop?
can't have, the officer says, well, they make whatever, they didn't turn their blinker on, or they had, whatever it may be, they changed lanes without signaling, but you didn't do anything, but you know you got stopped because you don't look like the officer just stopped you. How do you prove that?
That is,
I think,
are you going to law
Yeah.
school? Are you one of the pre-law students? You need to be. Well, that's a very good question, but one thing you'll learn in law school is there's a case called, is it Wren? WREN, Wren versus United States versus Wren, where the court held that the subjective motivations of the officer really don't make any difference. If the officer can state a reason, a violation of a traffic law, typically the reason for a stop, and that officer is credible and is believed by the courts, it doesn't really matter what his or her other reasons might have been. And the courts have told us that, and that's the law that we follow is. And so district courts have to make credibility determinations. We don't make that at our level, but in every traffic stop where there's a motion to suppress filed, the district courts are called upon to listen to the officer's testimony at the suppression hearing and listen to the defendant's testimony if it's offered or whatever the other testimony is, and make a determination of whether that officer's objective reasons for the stop are valid.
The statutes just don't help you if you're profiled and you are doing something illegal. It's when you're profiled and you're not, then that's where, right.
As a group of concerned citizens, I've been stopped and I didn't do anything, and they didn't find anything. I've been stopped and I didn't do anything, they found something. I understand the difference between the two, but what I'm saying is like, as a citizen, a group of citizens, anytime you're stopped, I know for me, if I didn't even talk to the police and I get away without going to jail, I'm happy. I could have done nothing. I'm just nervous around it. And a lot of my friends are the same way.
Me too.
So when we get away from them, we're away. We don't want to think about it anymore. It's a blessing because we could have got around the king. So it makes it a lot harder for us to be like, okay, well, I think I got stopped wrongly because you're starting up a whole hornet's nest when you really didn't do anything wrong.
But that's where we really need for people to make complaints and to really assert yourself in going to that agency, going to the KHRC, doing whatever you can do to assert your rights. Because the more complaints we have, I think the more we can, again, build that proof that police are not treating people the way they should be.
Well, hang on.
Well,
let me stop.
And we may not be able to use the statistical relevance in court, but I guess what I've been trying to say is internally in lots of agencies, we can make the case with some police chiefs then that some behaviors in some agencies needs to change and make them take the responsibility for what their officers are doing in their communities.
I really don't think there's a lot of police chiefs that don't want to know if they have an officer doing
Right.
that. They really do want to get those officers out. You may not believe that, but they really do. Now, two sides of that. The more times that an honest person, and now maybe you've done other things, but you didn't do anything this time, and you come forward and make that complaint, and you don't have any reason to do it, it adds credibility, it has that statistical basis, the chief's going to start worrying about that officer. The flip side is, the more times you do get caught, you did make the illegal left turn, and people come in there and say, oh, they just stopped me because I was black, Hispanic, female, wearing a turban or whatever, pretty soon the courts and the cops are going, yeah, right, another one. And we got you on videotape making the illegal left turn, yet you're saying, well, you only did it because I'm black. So they hurt themselves when they undermine the credibility, and we need honest people to come forward and say, hey, I've done other stuff other days, but that time I did not make any illegal turn. He just stopped me because I'm black. And we need that information in law enforcement.
Very much so.
I think we should also note at this point that an awful lot of the cases that we see, Fourth Amendment cases, may have a bad stop or a bad detention, illegality involved, but that has transitioned to a consensual encounter. This goes back to a comment that was made earlier. That is to say, no matter how you were stopped, if at some point in that detention it becomes consensual, then you've opened the door. So we're back to what we like to say. We are somewhat amazed to see how many people, when asked, "Can I search your car?" apparently think that they have to say yes. You just need to say no. And furthermore, let me say one other thing. That is, when the officer says he's gotten to the end of his investigation based on why he stopped you, he or she, and then says, you're free to go, but could I ask you a few more questions? Drive away.
Excuse me?
Hey,
Condoning drug trafficking here in front of everyone? There's no reason not to have a nice friendly chat with Officer Friendly. You don't have to. I certainly grant that. But on the other hand, there's nothing wrong with putting drug dealers behind bars. Yes, sir. Ma'am, I'm sorry.
It sounds like it's really, really hard to gather the statistics and they haven't been gathered. So, out of curiosity, why can't you just make it mandatory? The camera's always on, it's always charged, there's always a tape recorder. Again, you can get grants. That's not there. We've got $1 million that we can't do that with.
Unfortunately, can I answer?
Go ahead.
Unfortunately, the community is crying for cameras in vehicles, but I think they're what, about
$3,000 per car.
That's just for the cameras,
Just
but
for
to
the
really put the type of software that this particular company in Kansas has, our highway patrol can't even use their product yet because their
They have to
technology's
buy a
outdated.
new server. The technology has changed so much that use of cameras isn't as simple as it used to be. So.
And we all know that would make a heck of a difference. And then, to counter that, the policing entities that can't afford them or don't want to spend the money are saying, oh, well, it only gives you a vision of this much and that much. But we've, I think in a best case scenario, I'll tell you, I think that's the way that we're heading.
As an agency counsel, I love the digital audio recorders. I love the cameras in the cars. And we get those complaints all the time where they claim something, we pull up the tape and go, look at this. One issue that came up when we were first doing the bill in 2005 is they wanted to make it a criminal offense to do racial profiling. But one of the concerns was, what happens if you have a false report of a crime? Can we then turn around and charge that person with falsely reporting a crime, which we might be able to do. So it had a kind of a double-edged sword to it. But so yeah, from an agency point of view, they're great to have. Are there accusations? Well, before he turned that on, he did this. Sure, you're always going to get that, whether it's a Miranda situation or on the street. But it does help. There's some interesting technology where if you turn the light on, if the car is in motion, any number of ways where it can be triggered, the officer, certain motion detectors, things like that. But then you get into the storage issue as to how many tapes and how much data we're talking, and it really does add up. We have that problem just with taped interviews, what to do with all those, so and a dispatch log. So it is a big, big money issue. And then you end up with the officer time doing the reports, changing the tapes, and that takes more manpower off the streets become less safe, and on and on. Yes, sir. He will ask me anytime he wants. Professor K is not shy, so go right ahead. Your turn.
Disservice by stopping people and not giving tickets. I know that, for example, they say, I pulled you over because you took a ride on 6th Street and you didn't use your bike. They pull you over, you give your ID, and give your registration, everything, it comes back clean, and they say, okay, well, it's okay, you can go. But you need to do a little bit of disservice by stopping and not giving a ticket. They say, I saw you do something illegal, but you should just go ahead and give you a ticket.
I'm the moderator, so I'll defer to my panel. If I get a chance, I'll answer that. Does anybody else want to talk about that?
Did everybody hear
No,
the
I
question
personally
back
don't,
there?
yeah.
Did you? Okay.
The question was, is it smart or is it a disservice for an officer to give a warning ticket? To stop somebody, say I stopped you for an illegal left turn, you rolled through that stop sign, get their ID, run the tag, see if there's a wanton warrant. If there's not, they say, well, I'm giving you a break this time, have a nice day. I'm ecstatic when I get a warning ticket because I normally run through stop signs or I'm speeding. I noticed that. Yeah, I know. I agree. But on the other hand, absolutely, there are a lot of people that feel that the only reason they stopped me, if they had a legitimate reason, they would have written me a ticket. And I'm hearing that from officers. Never give a warning ticket. Never give anybody a break. They're just going to come back to bite you.
Yeah, but I think that was, Senator Bett's intention was, with this past year's legislation, that every time you're stopped, just so that they can track it, they want a ticket, not specifically a ticket that's going to cost me money or points, but to say, we stopped you, and now they can document, again, it goes into what this gentleman said. Now Steve Cisneros has like 25 warning tickets for whatever reason. Well, there's probably something going on there. So I think that's something to look at, but then again, that's a lot of folks voting on this legislation, and you have to trade-offs.
This is where I think the training of the officers is very, very important. Officers don't always understand what your perception is as the African American who stopped and then miraculously gets to go away. They don't understand often that you're sitting there thinking, did he stop me or she just because I'm African American? And what they need are, at least in my view, more opportunities and training to understand that and understand what it's like for people and how it is that these perceptions of profiling happen, so that they can maybe make some judgment, some discretion about, who deserves the ticket and where they're going to spend their time and stop the people and give the tickets, and maybe not perpetuate the perception of profiling by stopping people and sending them on their way.
And that's absolutely true. Again, a lot of officers are going, well, why are they upset with me? I gave them a break.
Right.
Professor Kay, would you have something to ask?
Well, no, not really, except to say this. I think it's amazing to hear such wonderful comments from judges who hear lots of cases and still have a fresh, open, and tolerant attitude when it comes to the impact of the law on minorities. One thing I think is for sure is that you can't expect too much too quickly from the bench, because as this gentleman is asking those questions, it's much worse than I think even what you think. Most of what they talked about was equal protection of the laws. That's what all the statistics is about. The U.S. Supreme Court said if you can show that, maybe you've got a remedy for this type of stopping and treatment, and that's fine. But as you can see now, it's very difficult to prove. But when it comes to the Fourth Amendment, the door is slammed shut. When the judge mentioned Wren versus United States, our officer sees you. He has an absolutely racial attitude toward you. He thinks of you in the worst possible terms, but he managed to find something you did. You drove too slowly, like my son did on I-70. Too slowly. He was going 60, not 65, and he got stopped, right? He had long hair, and he's a Latino. And that happens, but you have no remedy for that stop. That stop, the U.S. Supreme Court in Wren said, Justice Scalia said, that's okay. We're not going to second-guess an officer who's enforcing the law, no matter how trivial the law is. And then they went on to say, for example, if they did stop, they can take all the passengers in the car and make them get out. And Justice Kennedy said, my God, 10 million people are now in the hands of the police. And our state Supreme Court has said that we interpret our Kansas Bill of Rights exactly as the U.S. Supreme Court interprets the United States Bill of Rights. And so as a result of that, it's going to be very hard to get change. If they change the interpretation of the 14th Amendment, I noticed that Judge Green mentioned it, I heard you mention it. If they started interpreting the Bill of Rights through the 14th Amendment, which incorporates the right into the law today, they might start thinking about slavery. And slavery and the effects of slavery was to be eradicated. And that's why when someone like you is stopped by the cops and gets nervous, and they use that as a reason for further detention, or because you don't want to walk away from them when they say, can I talk to you further, because culturally you're stuck with your past, that should be taken into account. Right now it's not being taken into account. So around the country, like in California, what she is saying about going to the police departments and putting pressure on them, and maybe going to the legislature, though I have to say the legislature isn't always up to the job, but they might be if more people pressured them. That would be where the change would come.
What do you really think? Yes, sir. Officer.
Yes, sir. Have you ever had a complaint where an ethnic officer, a black or Hispanic officer, pulls over a Caucasian, and a Caucasian feels he did nothing wrong? He's being pulled over because he's white. Have you had anything like that? Would you take that complaint seriously?
It would fit the statute. Well, I'll let the judges determine that, but it would fit the statute if that was the basis for it. But
you've never had that happen?
I've never heard of it.
We've not had that happen, but if the person could prove that they were stopped on that basis, that would be impermissible.
We've had complaints. We've heard about complaints of Hispanic officers. I don't know if it was.
So you would review all these tickets and see if he's only pulled over white people, and you would put him in question?
Well, I think the Human Rights Commission would do that, or the agency would do that. It's not
No,
their
but in
job.
answer to your question, yes, they specifically mention in the largest city in Kansas a Hispanic surname who's an officer who is being accused of these types of tactics, whether it's a white individual saying he's doing it, or other Hispanics or other African Americans. So in answer to your question, it is, you are not I guess you're a part of this problem as well. And I'd mentioned earlier on the radio address that, it's not just white officers who are discriminating against African Americans and Hispanics. It's a mental culture, and that's what makes these things very difficult. You can't get in the mind of an officer.
Well, it's just, it seems like to me you make the white officer look like a villain.
No, I don't think so, sir. I think I think everyone is equally picked on when someone is not doing their job correctly, and I think that's kind of the most difficult thing when I work with the police officers on the task force, because these guys are good, honest working police officers, and then you have a few bad apples that spoil the bunch. I mean, I love Kansas. I still, just like this gentleman, I get nervous talking to police officers, but I don't care if they're white, black, Hispanic, purple, or green. They just make me nervous because I think I did something wrong. I call it the mommy Cisneros principle. Every time my mom called me, I thought I was in trouble. But I don't think that, I see where you're coming from, that, maybe in 2008, this, maybe things are turning over. You have every right to feel that way. I personally don't agree with you, but in answer to your question, yes, it does occur. African Americans do racially profile, Hispanic Americans racially profile, Asian Americans racially profile.
Let me just ask a quick controversial question. I'll get back to you. Is it any less wrong for the black community to think that all officers are going to Rodney King them than it is for every officer to think every black kid's a crook? Aren't they both racial profiling?
Yes, but one has power and one doesn't.
The history it challenges us differently. It really does, the effects of history.
Yeah. Yes, sir. You had a question.
Oh, I'm sorry. Before he speaks, I need to mention that Mr. Clyde Howard is a member of the Governor's Task Force on Racial Profiling, and we're really pleased to have his efforts and his supports to help us deal with this issue. He's been very good.
Well, I'm going to speak with my Human Rights Commission.
Oh, I forgot.
Yes.
He's also on the board for the Kansas Human Rights Commission, so he does a lot of civil rights stuff.
So, to your issue of would someone take your case? You pick up the telephone and call, someone will take your case. Now, there isn't going to be a predetermination that your case is good or bad, but they will take your case and it will be thoroughly reviewed. You will find out about the outcome of that case in a relatively short time. But it isn't a matter that the Commission doesn't take cases because you're white. The Commission takes cases on the basis of its jurisdiction. So if you raise the issue that you've been treated unfairly or racially profiled, it will take your case.
There was a question up there I've been directed to that's been trying to get my attention. I'm sorry. Which has the lowest percentage of blacks in America. But anyway, go ahead.
The officer said to me, when he came to the window, well, I initially pulled you over because you're out of state place, which I don't agree is a reason he's talking about.
It's not.
And he said, that's what he said to me. And then I had like little something hanging on from my shirt. He said, did you know there's an answer line in the state to have that hanging from your shirt? I immediately took it down. He said, can you please step out of your car? I said, for what? I said, you haven't even asked me for my driver's license and registration. Why do you want me to step out of the car? Is there something wrong? He said, well, we get a lot of blacks through this area that traffic and drugs. I said, sir, I just, my car is filled to from top to bottom. I'm going home from the army. He says, well, we can get. And another thing I don't agree with, cops are bullies. They are bullies. And when you get stopped, it's not simple as saying no. They make you think, I'm a black female, 23 at the time, alone on a Montana highway. I'm scared to my I'm so scared, I'm I'm like, oh my God. So, and I didn't have my cell phone at that time. So I'm just so scared, I'm kind of shaking. He's like, you know, and then when he says, you know, he's black, I'm like, so I said to him, why? I was like, well, you know, I'm not from Washington, I'm actually in the military and I'm on my way home. He said, I don't believe you. So I take out my military, I go to take out my military ID because I had that in my back pocket, but I had the license and registration on the other seat. And he says, if you make another move, I'm gonna shoot you. And I said, I'm like thinking in my head, this is a nightmare. What happened? You put me over because I had an out state, then you stop black people, you know, it just kept escalating and escalating. And my whole thing, you know, I didn't report it, I didn't do anything. I just kept thinking, no one is gonna believe me. And from this whole panel, that's what I got. You're not gonna believe you treat the victim, the victim has to prove it, and the cops get away. Like, the state is, you know, protecting the police officer. I asked that police officer for his badge number, he wouldn't give it to me. I stood on that highway for 4 hours. And he didn't give me a ticket. He refused to give me a ticket because I said, I was like, I'm not leaving here without a ticket. I want something. I'm on this road and it goes to nowhere. All I see is fields all around. I'm from the city. I'm from Massachusetts. I ain't never seen that many fields in my life. So I'm like going crazy. Like, I'm like, you know, looking for something that I can go, you know, complain. Like, why did he leave me out there on that road for 4 hours? And just listen to this. It makes me feel like, you know, still, that was like 6 years ago. And still, listening to the judges, there's no, even for good people, I never got stopped by a police officer in my life. First time, and it was the worst experience of my life. So now when I get stopped, and I've been stopped once at a time. I am like that guy said, I am scared. Because being a female alone and a white man stops me, I'm scared. Any man stops me, I'm scared. First of all, not even just a white man. Any man stops me by myself, I'm nervous. I'm a woman. But then he just kept, you know, escalating the situation. And just me sitting here just listening to you guys, it's like there's no hope. Like, you lump people in one situation. And that's what police officers do. They say, okay, you're black, so you're gonna be involved in drugs. No one in my family is involved in drugs. No one in my family has ever been to jail. You know?
I'm not saying we're not. Good job. I think I got your point here, but we got to wrap up. We're out of time. Let me ask one point. The judges are saying about civil cause of action and Fourth Amendment suppression, you have certain burdens that the Supreme Court has set. And I understand that. That isn't necessarily true that there is not a remedy. You know, agencies will and do discipline their officers for bad acts all the time. So, if all officers have their name on their uniforms, you know, and it's got the name of the agency and it's got the name of the officer on it. I know you're scared, I know you're frightened, but try to get that information. Do report that to the agency. Now, I'm not swearing it's going to fix anything. I'm not silly or that naive. But good agencies want to know that they have officers like that. They will take action. And again, if there's multiple reports, pretty soon if there's that much smoke, you get some fire. So I think there is something less than the civil action, less than criminal cases, but you know, there are bad officers. There are bad students, there are bad priests, there's all sorts of bad people. We got to get rid of them. But we can't get rid of them if we don't have the information and the evidence. I know it's tough, I know it's scary, but we got to have that information.
Yeah, the most important thing you can do is make those complaints. And what I've also learned is that one of the most important things we can do in the future is for officers to come to training often and hear these stories. They've never sat in a room and sat across the table face to face with a young woman of color who has that kind of story. They need to. They need to hear that, understand that, and have a process where they understand how bias may impact their work so that they can operate differently and so that they can deal with anybody under their charge who behaves in that way. And
And
so I just think it's real important for you, if it ever happens again, or anybody in this audience, to make your complaints and be a part of making sure that officers and their leadership know what happened to you.
And I think we should come back because it's of a grave concern that she is saying, well, is there any hope? Is there any hope? I heard that question. And I think I want to echo those comments. If, hypothetically, this had happened to you in Kansas, I don't know, Montana, I don't know what's going on statutory-wise there, file your complaint. Absolutely file a complaint under the facts that you have related today. I would confidently say that the Kansas Human Rights Commission would look at that very, very seriously. And beyond that complaint, exert your rights to file a civil action, a civil cause of action, which is available to you already under the Kansas statute. It may be difficult. We've emphasized the difficulties, but nonetheless, you have to exercise those rights. And is there hope? There is absolutely hope. Either before the commission or in our courts. We happen to think that in Kansas we have some very fair and impartial courts, and you bring that case to our court, we'd be happy to look at it. I'm not going to tell you how we're going to rule, but I want you to know there is hope for anybody who suffers that kind of profiling in this state.
Yes, ma'am.
A few years ago, a friend of mine was stopped similarly to how the young man over there was stopped. Only the not sole reason was failure to maintain a lane. It did happen to be in Roscoe County, so I was really interested in what you had to say about the deputy there. But I wrote a letter to the sheriff who said, no racial profiling involved. And I copied it to the provost for diversity here, the vice provost. Actually, I forget exactly what the title was. But
Provost for diversity and dual career development involves.
Yes, that's what it is.
Lucky guess.
Because the student was, the young man stopped was a UCLA student coming to visit his K-State student brother. And I thought that it gave a bad view of our state. I'm thankful to hear from you other places that you can send these letters, because I think that, one, people have to know that it's happening, and two, for those of us in the majority community, we have to tell others in the majority community that it's happening, because it doesn't happen to our sons at all.
Somebody mentioned the Attorney General's website. There is a complaint form you can download and print off at that website. Let me throw out one little kicker here, too. Guess how many complaints the Kansas Human Rights Commission has had on racial profiling in the 3 years the law's been in effect? You said it happens every day. How many do you think we got?
Is that number still 34, Rick?
49? 49 in 3 years and 3 months.
It was 34 last year.
And 4 of those, they made enough to probable cause finding. Now, if I'm an administrator, if I'm the legislature trying to decide what to do with this bill, I'm saying, this isn't a problem. We're not going to spend any money on this. If that's all the complaints that are going on, we got better things to spend our money on than this, so we're not going to buy any cameras. So, if something's going on, agencies need to know, the legislature needs to know, the AG needs to know, Rights Commission needs to go on. But if it's just, no big deal, nobody's going to bother to report it, then you don't expect your legislator to act.
If you can't recall who to call, where to go, call the governor's office. They'll transfer you to Steve or my office, and then we'll be sure to get you in the right place.
Yeah. Oh, we get more questions. Yes, ma'am.
What if you're driving down I-70 and you see all the Hispanics being stopped and searched, for illegal aliens?
Well, I would first say don't assume that it's an illegal stop. You don't know why they got stopped. It may have been a drug bust. It may have been a culmination of a 12-month investigation. So as a law enforcement officer, just because you see a minority stop doesn't mean that it's illegal.
Well, it really upsets me here in see that the officers are now being turned into immigration agents, so they don't really have the training for that. And it happens in our community too. People are rounded up, and because they're Hispanic, if they don't find anything in their car or their houses, then they're turned over to immigration, they call Kansas City and come get them.
Yeah.
It's another area.
Your opinions about this intersection between immigration law and
And the judges want to jump into that quiet little briar patch?
It's another area where officers' training hasn't kept up with the times and with what's necessary. And we've talked a lot with law enforcement leaders about that.
And the flip side, the legislature keeps pushing, I don't know if they ever passed it. I left last year before they did.
No,
but-
they did.
Yeah, they keep mandating law enforcement officers investigate that and they make an inquiry on every stop. And law enforcement's never asked for that.
There
They
are
got enough
some-
to do.
There are some jurisdictions, I think, where they've been asked to do that.
Yeah. That was a big issue when I was in D.C. because Maryland had done that. I'm sorry, Judge, did you want to say something?
You've got the wrong panel of judges to talk about immigration. That's a federal matter, and yeah.
Without the appropriate training. That's the key. And
Okay.
as citizens, you again, to demand they're given the responsibility, they also are given the appropriate training, so they don't abuse the law.
I have the authority to cut her off, I just don't have the will. We have time for one last question.
Sorry.
It's back in the very back, you.
One person mentioned that public approval of racial profiling increased drastically after September 11th. So how has that changed in the last 7 years? Is it continuing to increase? Is it leveled off? Is it decreased? What's the current status of public opinion on racial profiling?
That was the last statistic that I quoted, but I mean, obviously with the whole, not only with just 9/11, but as you can see with, this political volleyball, we just now know as immigration, it's increased. And, it's unfortunate. We have a lot of uneducated people out there, and I think that's kind of part of the big issue. So it's sad. And then, again, I didn't have a chance to tell you, but I have a daughter, the young woman up here, and I just want to apologize that that happened to you. I don't know if anyone ever took the time to tell you.
Okay.
I have a really quick question, I promise, and not as a member of the media. I'm putting my camera away. Do you, as a person who is stopped, have the right, I've heard this, have the right to go to some place where you feel safe, even if a cop is trailing you?
The law requires you to pull over at the first available spot. If it's a block or two, I don't think anybody's going to care about you pulling into the 7-Eleven stop if there's other people around. If you start going 3 or 4 blocks, they're going to get you for fleeing a lewd, and you have no right to do that. That's my reading of the law.
Shouldn't be too far, and you shouldn't drive too quickly.
Yeah.
Slowly and close.
And if you want to, if you got your cell phone, call dispatch.
Right, do you have the right to do that?
You have the right to use your
make
phone.
a phone call and say this person is trailing, because there are people posing as cops.
Absolutely.
And do that also.
Absolutely. And if it's not a marked vehicle, I would do that.
Yeah.
But if it's a marked vehicle and it's got the lights going, I think, saying, well, I didn't know you were a real cop, isn't going to fly over real well.
Right, it's saying, I don't feel safe in this deserted, neighborhood as a young, well, not as young, but as a female, especially
It gets into
tonight or.
Yeah, it gets into a distance. But again, if you really are concerned in that area, get on the phone, call dispatch, explain that. They can get on the radio, tell the officer, okay, she understands you're behind her, she wants to pull over up at the quick shop or whatever, and that will normally work.
Okay, thank you.
Okay, real quickly, on behalf of myself, I want to thank you all for sticking out. We went a little bit longer than we intended to. I want to thank our esteemed panelists, Judge Green, and Skaplinger, Steve, and Ms. Wolf. It's just wonderful seeing you again. Thank you all. Thank you.
Excellent job. Let me again thank our panelists for giving up the time to come here to be a part of the Constitution Day and also the Dorothy L. Thompson Civil Rights Lecture Series. Thank you for giving up your time to be here and to deal with this most critical issue in our state and in our country. We have cookies and drinks in the back. Please join us. Let's give our panel another round of applause.